Good afternoon. Welcome to the afternoon section. You have, as the first lecture, we'll have ProfessorGeraldMäsch. I hope I don't know, my German is not good enough, Mesh. And he will address the topic of compulsory licensing of patents for the common good, new developments in EU and German law. So, Professor, please.
Caros colegas, estou feliz e grato por estar no Brasil pela primeira vez e de poder participar deste workshop. Well, that's about it with my Portuguese. Now I will switch to English. As you can see, my paper deals with intellectual property rights and the interplay between the ownership protection of these rights and on the one hand, and on the other hand, the public good and the protection of competition. Now, it's a very technical issue, much more technical than what we heard this morning about political activism of constitutional courts, Wittgenstein's hinges, and the idea of private autonomy. The one person who might be familiar with this subject is not here. Professor Krüger cannot be here at this moment. For your advantage, I pledge to be shorter than some of my predecessors. The world battled the coronavirus pandemic for 3 years, roughly between 2020 and 2023. Intellectual property rights, especially patents, have proven to be both the good and the evil for an effective COVID-19 response. On the one hand, the remarkable efforts we witnessed to rapidly develop vaccines would not have been made if the pharmaceutical industry had not been certain that their efforts would pay off in the end. And this requires patent protection. On the other hand, I don't want to disrupt your afternoon news. Okay. On the other hand, patent protection carries the risk that the patent holder is not able to produce a vaccine in the necessary quantities and or charges such a price that entire section of the population or even entire countries aren't able to afford it without other companies being able to step into the breach. And thus, patents and other intellectual property rights can act as barriers to healthcare delivery. True to Churchill's motto, never let a good crisis go to waste, the European Commission has in 2023 seized the momentum created by the pandemic as an opportunity to leave their own mark on the European patent system. In spring 2023, it has issued 2 proposals for a regulation. First, a regulation on compulsory licensing for crisis management, and second, a regulation on standard essential term patents. In this paper, I suggest having a brief look at their content, but I would like to think that to be able to truly assess the merits and the impact of these proposals, if enacted, we first need to sketch the current landscape of compulsory licensing of patents in Europe. And the current system we can divide into two approaches reflected in the two proposals. The first is the compulsory licensing in the public interest under patent law, and the second, the compulsory licensing under competition law with a view to protect competition. Now, coming to the compulsory licensing today with regard to the common good. You can see here how it works under the German solution in Section 24 of the German Patent Act. You don't have to read everything on this slide, but you see here that the grant of a compulsory license by the Federal Patent Court is subject to two conditions only, but these two conditions are high hurdles. First, prior to the application for a compulsory license, the applicant must have entered into serious negotiations to obtain a license from the patent holder on reasonable conditions that are usual in the trade. Serious negotiations on contract terms for a license take time, much time. And for this reason alone, the compulsory license under Section 24 Patent Act is no quick fix for a crisis situation like the COVID pandemic. And secondly, the grant of the compulsory license needs to satisfy the public interest test. Now, this is an undefined legal term that must be interpreted by the courts. The Federal Court of Justice remains very vague in the starting point, which is, in my view, understandable given the broad scope of areas in which patents exist. So according to the court, technical, economic, socio-political, and medical considerations are all considered possible circumstances that justify the assumption of public interest. However, because compulsory licensing is a serious encroachment on the constitutionally protected rights of the patent holder, these circumstances, according to the court, must be extremely compelling. So it's no wonder that since the inception of this provision in 1961, there were only about 20 applications for a compulsory license under Section 24 of the Patent Act. And only one of these 20 applications was successful in the end. It was concerned with an HIV, an AIDS drug marketed by Merck. So the essence, Section 24 of the Patent Act is not exactly dead law, but it is of a very, very limited practical relevance. Now, coming to compulsory licensing today under competition law. Now, you remember, maybe some seconds ago, I said that under Section 24 of the Patent Act, the public interest that warrants the granting of a compulsory license could have technical, economical, social, or medical aspects. And significantly, something is missing in this list. This list of possible grounds does not include competition. In other words, potentially anti-competitive conduct by a market dominator is, for example, a refusal to grant a license on reasonable terms is in itself not a ground to grant a compulsory license under Section 24. So competition law is able and needed to step into the breach. Under competition law, this means European and German law alike, it is prohibited to abuse a dominant market position. Under European law, this principle is set out in Article 102 of the Treaty on the Functioning of the European Union, TFEU. The German equivalent is Section 19 of the Act Against Restraints of Competition, which, unlike Article 102 TFEU, specifically mentions our problem in subsection 2, number 4. can see there abuse exists, in particular, if a dominant undertaking as a supplier of a certain type of goods or commercial services refuses to supply another undertaking with such a good in return for adequate remuneration. If the refusal threatens to eliminate effective competition on the market. That's in short what's stated in Article 19, Section 2, and number 4 of the German Act against Restraints of Competition. Now, as regards patents, a patent holder is in a dominant position if his patent must be used to compete on a specific market. And in this sense, a dominant position by a patent holder is generally deemed to exist in case of patents pertaining to established standards that must be used to compete on the market and cannot be circumvented or substituted by other solutions. Now, these patents are called SEPs, Standard Essential Patents. And prime examples of such standards are Wi-Fi, Bluetooth, or concerning the mobile telephony internet sector, the 5G technology, just like 2G, 3G, 4G before. In such scenario, the courts consider that there is a separate licensing market for the relevant SEPs, on which the SEP owner, naturally, holds a monopoly position, which potentially allows them to control markets that are dependent on the implementation of the standards. And if he declines to license his patents, he might abuse his position under Article 102 TFEU or Section 19 of the German Act. But as you can see in number 4, he must supply the goods in return for adequate remuneration. In IP parlance, that means that the holder of a standard essential patent must offer his competitors a non-exclusive license under fair, reasonable, and non-discriminatory conditions. In short, under FRAND conditions. You can imagine that in practice there are fierce disputes about which license fees and other contractual terms are to be deemed FRAND. Given the wide variety of possible scenarios, the courts cannot and do not wish to provide more than rough guidelines for these negotiations. And was habe ich jetzt gemacht? The ECJ has instead opted to specify the requirements of how to negotiate FRAND terms rather than reviewing the terms themselves. And in reference to the name of the decision in which the ECJ developed this approach, these negotiation steps have been given the catchy label Huawei dance. Needless to say that this shift to a procedural perspective provides for much flexibility on behalf of the parties and on behalf of the conditions, FRAND terms, but lacks precise guidance on the content of a FRAND license agreement and thus leaves practitioners in a precarious situation. Now, to sum up the status quo, compulsory licenses for this common good of the public interest are a more or less theoretical option with minimal practical relevance today, whereas a tussle about a compulsory license for a standard essential patent is a rather frequent event in European business life, but the uncertainty surrounding the question of what constitutes FRAND terms also greatly reduces the practical significance of this instrument. Now comes in the European Commission. The European Commission has adopted on April 27, 2023, a proposal for a regulation, you see the title here, on compulsory licensing for crisis management. Now, if we remember Article 24 Patent Act, German Patent Act, you have two conditions for a compulsory license: for the common good, for the public interest. I will not ask you in hope that somebody really remembers, but I'll tell it again. You need failed negotiations and the public interest test. Now, the European Commission changed the approach. There's no need for failed negotiations. Oh, this is a wrong here. This is an old version. So no failed negotiations needed for a compulsory license for crisis management. Instead, the European Commission constitutes an advisory board that will reflect on the possible need for a compulsory license and for the conditions to be used in a friend way. And the first condition under German law, the public interest, is substituted by the term of crisis. You need a cross-border crisis or a cross-border or emergency situation affecting the entire EU. And then, if this is the case, then a compulsory license will be issued with a clear specification of scope, coverage, and duration, the fixing of the compensation, and there might be additional obligations for licensees. And what is not yet inside this regulation, but in another regulation, there could be a suspension of data and marketing exclusivity protection for the patent holder. That is interesting for clinical studies needed before a drug can be offered on the market. So no public interest, no failed negotiations. There are still points of criticism for these, this proposal. Okay, no public interest, but crisis. What is an EU-wide crisis? Or what is an emergency, EU-wide emergency? Both terms are not defined in the regulation, in the draft regulation, and possibly cannot be defined in our opinion. And secondly, what are products, drugs in this case, that are indispensable for responding to a crisis? They might be good for responding for a crisis. They might help ending the crisis. But when is a product indispensable? That is certainly open to discussion. The issue of trade secret protection and know-how that are not terms of a patent are not addressed. The license will end with the end of the crisis. When the crisis ended, you have no right anymore to produce a product under the compulsory license. Now, that can be very quick, and at the same time, it can be open to a lot of interpretation. When did the COVID crisis really end? Can you put a date on it? I wouldn't know. And last but not least, this solution is EU-focused. They grant an EU-wide license for a patent, and the world beyond Europe doesn't exist. The problem with COVID vaccines was that they were too expensive for countries in the global south. This problem is not solved under this EU regulation. No, oops. Now we come to nearly to the end. A joy. We come to the draft regulation on standard essential patents. I do not want to speak on the content of on the scope of the relation, but on the content. It is very interesting. No. No, there will be an SEP register. So every holder of a standard essential patent is invited to register this patent. Invited. This is voluntary. But if it doesn't do so, and there will be a compulsory license issued, you won't get any royalties. So it's a nice term saying this is voluntary. You need to. So it's you have to register your SEP in order to protect your rights. Then look at the third point, the friend terms that are so difficult to ascertain. They are determined by a panel of experts, third parties. This is, and you see it in the end, and this panel is supported by a competence center at the EUIPO, the European Union Intellectual Property Office in Alicante. And so the parties, the holder, the patent holder, and the would-be licensee, they don't have to deal directly with themselves. They have help with an expert commission panel, as they say in Brussels. Now, I will be short, I promise. So we come already to the outlook. I think the proposed regulation on compulsory licensing for crisis management will not have a great impact. I listened to the points of criticism. It's a nice thing to have, but it won't change the world. As regards regulation on standard essential patents, this is quite a different thing. In my view, that can definitely be a boost for EU innovation. And at the same time, a model for solving other disputes between undertakers, to help them solve the problems by kind of mediator. You know, this advisory panel makes a proposal for the friend terms, is kind of mediator, helping the parties to find a solution. And in the regulation, the draft regulation, it is said that shall not take more than 9 months, these negotiations, the friend terms. So this is an interesting shift towards a procedural perspective. Instead of really trying to fix different issues by law or by the court, the emphasis is on a procedure to find the necessary friend terms. And this might be a bit too stark, but this, remember, is made of Luhmann's legitimacy by procedure. It's not the end that counts, but the procedure to find the end. And that's the end. Thank you for your attention.
Thank you very much, Professor GeraldMäsch. And I ask the audience if there are any questions. Okay, so in the first block, we have Professor AlbertoAmaral, and then Niels Petersen and James Falls. So Professor AlbertoAmaral, please. Maybe yes, because of no need. Okay.
Okay, as regards the first question, are compulsory licenses boon for innovation or stop hindering of innovation? First of all, as patents in general, patent protection in general, and you mentioned it even more often than I did, is of course itself a necessary means for innovation. Only if I can pick the reward of my innovation, then I will do it. But we're talking here only about SEPs, about standard essential patents. A standard essential patent, if not licensed, hinders the competition and the innovation on a following market. You know, if the one company that has the F5G patent is not required to give a license to other companies, then there would be no competition on telecommunication, on mobile telecommunication whatsoever. So in this regard, compulsory licensing for standard essential patents and standard essential patents only is needed to give a boost to innovation. Then I'm pretty sure of. I think that answers your question. Of course, there's no question of forcing someone who has entered the weight loss drug to give them license, to give a license to another pharmaceutical industry. No. But if your patent hinders the competition on another market, then becomes a question for compulsory licensing. Yeah, you asked where to draw the line. The line is standard essentiality. That is not always easy to define. What is standard essential, and are there other ways to compete in the other market than by using this patent? But that's another way of stating that there might be an interest in having an SEP register. Yeah, the Global South, as far as I am aware, this was no point of discussion during in the commission for presenting the regulation. Today, the parliament has voted on both draft regulations favorably with minor amendments. But even they are not aware of any discussions in this point. And you pointed out to the jurisdiction problem and other problems. The Commission is not in a position to save the world. Nor does it want to. But still, it remains an issue. It remains an issue that needs to be addressed. Maybe TRIPS, but we all know how inflexible, or yeah, it's a fair way to say it, how inflexible this system is. So I wouldn't pin much hope on it.
For a second round, I think we have Ronaldo and Marcos. So please. If you allow, I would like to to present a question, to establish a dialogue between my field, that's environmental law, and your field. And I wonder if the green technologies that would be perhaps used or necessary for, reducing emissions at energy production or transport, for instance, and whether they would qualify as essential patents, and in which way do you think that compulsory license would be positive policy in order to spread the use of these new technologies and combat climate change?
I must say that I didn't think of artificial intelligence in this respect. I think patents have not much to do with artificial intelligence, maybe more copyright law and stuff, but patents, no. So the question of standard essential patents and artificial intelligence, I think is, maybe I'm wrong, but no, it has no practical relevance. The same vein, patents for the common good and artificial intelligence. Perhaps my fantasy isn't enough. But you would have to argue that there might be some copyright issues that you have to solve with compulsory rights to make use of artificial intelligence born programs, or, well, might be the case in the future. I didn't stumble on anything like that in my research. Regarding the jurisdiction on compulsory licenses, this remains a national topic. The administration of the compulsory licensing under the proposed regulations remain a thing for the member states, and the details must be formulated by the national, by the member state himself. Was it all, or did you? There will be one decision on one European-wide license, and this license will cover each and every national patent inside the European Union and also the new EU patent. It's the same way. So there shouldn't be, at least in theory, but I don't know how it will work out in the end. There shouldn't be a competition between the different states, because the German patent can only be licensed for German territory, and vice versa for the Italian patent, even under the umbrella of a European patent. They still remain national patents. And the EU patent is not a national patent anymore. There, I don't know, maybe there will be the European Patent Court deciding on the license. Climate change, tough question. You have to bear in mind that you're talking about the compulsory license in the public interest, or on the competition issue. Well, Now, under Section 24 of the German Patent Act, that would be feasible. You need only a public interest, and the public interest could lie in these environmental or climate change issues. The proposed regulation wouldn't help here. It's a regulation for crisis management. You need an acute crisis and not something building up for centuries now. So no, this is one of the point of criticism towards the regulation. It's the first hand, it seems to help because you don't need this public interest. But on the other hand, it takes it away by the need for a crisis or an emergency issue. And it must be an EU-wide crisis or emergency situation. So no, it wouldn't help.
Thank you. And any other questions? I think we managed to be on time during this panel. I wonder, do we have another speaker? Yeah, no, I have actually two different versions, I'm afraid. And I would have, here I have Virgílio. Now you change. Okay, so we have Luis Fernando. Okay. Okay, so we have a professor, let's just, cadê o seu? Aqui. Onde está o seu? Aqui. We have Professor LuisFernandoMassoneto from the Law School of the University of São Paulo, who will speak about law and underdevelopment beyond the sociological approach.
Hello, good afternoon. It's a pleasure to me be here in this lecture. I wrote a proposal of an article. It's still a draft in a dialogue with Professor Peterson production, important test about a social science approach. And I try to establish to write an argument in dialogue with Professor Peterson. I will read, beg your pardon for my not so good English, but it's a decolonial essence manifesto. So the registers only. Beyond the economic hegemony, Peterson's methodological pluralism and the Latin America critique of conservative modernization. Introduction. The problem of empirical assumptions in constitutional law. I want to discuss a fundamental problem in contemporary constitutional adjudication: how courts deal with empirical questions that underlie their normative arguments. To frame this discussion, I will begin with the work of Niels Peterson, whose 2013 article, Avoiding the Common Wisdom Fallacy, provides crucial insights into the challenge, then connect his arguments to broader questions about economic hegemony and Latin America developmental thought. 1. Peterson's central thesis: the unavoidable role of social science. The historical context. Peterson begins with a striking observation. While the US Supreme Court has been using social science evidence for over a century, from Miller versus Oregon in 1908 to Brown versus Board of Education in 1954, this practice has not resonated with constitutional courts outside the US, particularly in continental Europe. This creates a puzzle. Why do courts avoid empirical evidence when their reasoning increasingly depends on factual assumptions? The core argument. Peterson's central thesis challenges a fundamental assumption in legal thinking. He argues that constitutional legal reasoning cannot escape empirical considerations because normative arguments are often based on implicit factual assumptions. The traditional separation between is and not breaks down in practice because 1. Normative categories shape how we perceive reality. Our legal concepts influence what we see as relevant facts. 2. Empirical knowledge influences normative choice. Our understanding of consequence affects our value judgments. And 3. Constitutional interpretation frequently requires consequentialist reasoning, especially in equal protection, individual rights adjudication, and interpretation of open-tester constitutional provisions. 3 areas where empirical evidence becomes crucial. First, equal protection clause. When courts address indirect discrimination, they must assess the actual effects of seemingly neutral policies. The Brown decision exemplified this. The court needed psychological evidence to demonstrate that separate but equal cause concrete harm to African American children. Second, individual rights adjudication. Proportionality tests require empirical assessment at each stage. Does the measure actually promote its stated objective? Are these less restrictive alternatives? What are the real costs and benefits of the restriction? Third, constitutional interpretation. When constitutional language is indeterminate, courts often resort to teleological reasoning, which depends on empirical assumptions about how institutions actually function. This is a past draft. I hope it's correct, Professor Peterson. Second, the problem of economic hegemony, the Zelez Palace Wars, the transfer of symbolic power. This brings us to a broader context that Peterson doesn't fully address, but which is crucial for understanding his argument's significance. If the Zelez work on palace wars documents how, particularly in Latin America, there has been a transfer of symbolic power from traditional jurists trained in the European civilian tradition to the new elite of technocrats trained in neoclassical economics, primarily in American universities. The law and economics movement as a hegemonic project. The law and economics movement was not merely a neutral tool of analysis, but a hegemonic project that 1. Reduced complex legal questions to efficiency calculations. 2. Naturalized neoclassical assumptions, rationality, market efficiency, methodological individualism. 3. Delegitimized other forms of social knowledge as unscientific. This creates what we might call an economic imperialism in legal thinking, the assumptions that economic analysis provides the only rigorous approach to social questions. The limitations of neoclassical economics in law. As Peterson observes, this economic analysis is often based on microeconomic theory, which deals with individual interactions, while constitutional law frequently addresses much broader social phenomena. The neoclassical toolkit simply doesn't fit many constitutional questions. Moreover, the uncritical absorption of neoclassical perspectives by just systems presents fundamental problems. 1. Questionable anthropological assumptions. The Homo economicus model doesn't correspond to psychological reality. 2. Oversimplified view of institutions. Efficiency as the only criterion ignores values like equity, dignity, and democratic participation. 3. Universal market solutions, ignoring market failures and power asymmetries. 3. Peterson's pluralist alternative, beyond economic monism. opening constitutional analysis to multiple social sciences. Peterson's proposal is important precisely because it breaks with economic monopoly in legal social analysis. He explicitly suggests that the constitutional lawyer may refer to political science, sociology, or cognitive and social psychology in order to illuminate the empirical assumptions of his normative models. This formulation challenges the hegemonic project by breaking the economic monopoly on social analysis in law, recognizing the multidimensional complexity of legal phenomena, admitting the different disciplines can offer complementary insights. 3 strategies for dealing with empirical questions. Peterson analyzes 3 potential strategies courts use to handle empirical questions. 1. Autonomous judicial interpretation. Courts evaluate empirical questions themselves. The problem: most judges lack training in social science methodology and can fall into what Peterson calls the common wisdom fallacy, drawing conclusions based on intuition rather than rigorous analysis. 2. Legislative margin of appreciation. Courts defer to legislators when social science evidence is inconclusive. But this raises the question: who decides when evidence is inconclusive? Courts still need to make their own assessment. 3. Expert delegation. Courts defer empirical questions to social science experts. However, judges still need basic methodological knowledge to evaluate expert opinions and understand their normative implications. The smoking ban case, cautionary tale. Peterson's analysis of a German constitutional court case illustrates these problems. The court concluded that smoking bans cause revenue losses in restaurants based on simple percentage differences between states with and without bans. However, they failed to check statistical significance or control for other variables, weather, local economic conditions, etc. This led to decisions based on questionable empirical assumptions. 4. The Latin American developmental critique, historical precedents for methodological pluralism. The UN Economic Commission for Latin America, CEPAL's historical structural method. Here's where Peterson's argument connects powerfully with Latin American developmental thought. The CEPAL school, Prebisch, Furtado, Sunkel, Cardoso, developed a fundamental epistemological critique that anticipates Peterson's argument by decades. 1. Against abstract universalism. Economics cannot be reduced to universal abstract laws. Each social formation has its own dynamics that must be understood on their own terms. 2. Structural analysis versus functionalism. The economy is structured by asymmetric center-periphery relations. Underdevelopment problems are not correctable market failures, but structural characteristics. 3. Social totality. The impossibility of separating economic from political, social, and cultural dimensions. Conservative modernization and legal transplants. The conservative modernization critique is particularly relevant to understanding how economic imperialism operates in law. Conservative modernization in law operated through uncritical legal transplants, importing legal institutions without considering the receiving social structures. 2. Legal form fetishism, believing that normative changes automatically produce social transformations. And 3. Conflict neutralizations, using law to depoliticize distributive question. Peterson's method as a tool for denaturalization. Peterson's offers conceptual tools to question the empirical assumptions of conservative modernization. A pluralist analysis would ask: 1. Historical structural questions. How did these institutions function in origin countries versus receiving contexts? 2. Sociological questions. Which social groups benefit suffer from these changes? 3. Political questions. How do these reforms alter existing power relations? 4. Psychological questions. What are the impacts on expectations, behavior, social identities? 5. The Economic Law School, a theoretical bridge. The Franco-Brazilian tradition. The Economic Law School, Comparato, Grau, Berkovich, following Savatier, Farjat, offers legal foundations for Peterson's pluralist approach. Critique of legal formalism. Law as an instrument of social transformation versus law as an anthropoetic system. 2. Political legal analysis method. Economic law as synthesis, overcoming public-private law dichotomy. 3. Systemic perspective. Law as a subsystem of the broader social system. This tradition converges with Peterson in rejecting the absolute autonomy of law, proposing interdisciplinary analysis, and emphasizing the social consequences of legal decisions. 6. Practical applications toward developmental jurisprudence. Reformulating constitutional questions. Let me illustrate with a paradigmatic case, intellectual property and development. Traditional approach to law and economics. Patent protection incentives innovation. Free markets of ideas maximizes social welfare. International harmonization is efficient. Historical structure approach informed by Peterson. Comparative historical evidence. How did currently developed countries treat intellectual property during their catching up phases? 2. Sociological analysis. Who benefits from current IP regimes? How does this affect innovation capacity in peripheral countries? 3. Political perspective. How do these regimes affect technological sovereignty? What alternative exists? Methodology for development case. I propose 3 tests for development-oriented constitutional analysis. 1. Structural specificity test. Does the legal solution consider the specific characteristic of underdevelopment? Is there historical evidence of effectiveness in similar peripheral contexts? 2. Distributive impact test. How does the decision affect different social classes? Does it contribute to concentration or deconcentration of income and power? 3. National autonomy test. Does it preserve or strengthen capacity for self-determination? Does it contribute to productive diversification or deepen primary specialization? 7. Institutional implications and legal education reform toward a post-colonial juridicity. The convergence between Peterson's methodological proposal and Latin American's critical tradition suggests possibilities for constructing post-colonial juridicity characterized by 1. Epistemic autonomy, capacity to produce legal knowledge adequate to regional specificities. 2. Critical structural method, analysis of concrete social functions of legal institutions. 3. Transformative project, conscious use of law as an instrument of overcoming underdevelopment. Legal education reform. This requires fundamental change in legal educations. Latin American economic history, understanding specific development trajectories. Comparative political economy, analyzing different development models. Legal sociology, understanding social effectiveness of norms. Social science methodology, capacity for critical evaluation of empirical evidence. Conclusion. Law as a tool for autonomous development. Beyond intellectual colonialism. Peterson's methodological sophistication, when articulated with Latin American critical tradition, offers foundations for developmental legal hermeneutics that 1. Denaturalizes dominant legal solutions by explicating their empirical assumptions. 2. Reterritorializes legal knowledge by considering historical and structural specificities. 3. Democratizes legal evidence production through methodological pluralism. 4. Instrumentalize law as a conscious tool for social transformation. This represents not merely technical sophistication, but a reconquest of interpretive sovereignty, the capacity to understand and transform social reality through proper legal categories, informed by the best regional critical tradition and contemporary methodological advances in social science. The path forward. The challenge is not to turn judges into social scientists, but to ensure they cannot be completely ignorant of empirical methods either. This requires 1. Combine strategies, using multiple approaches depending on the case. 2. Basic methodological literacy. Understand when and how to use different types of evidence. 3. Institutional reforms. Create mechanisms for better integration of social science evidence and legal reasoning. What we are ultimately proposing is a sophisticated resistance to economic imperialism in law, not through rejection of rigorous analysis, but through methodological pluralism that serves genuine social transformation rather than the reproduction of existing power structures. Constitutional adjudication in developing countries requires this kind of epistemic decolonization. Peterson's work provides methodological tools. Latin American development and thought provides theoretical foundations. Together, they point toward a more democratic, reflexive, and socially situated approach to constitutional interpretation. The question is not whether courts should consider empirical evidence. They inevitably do. The question is whether they will do so consciously, rigorously, and in service of a genuine social transformation, or unconsciously, through the reproduction of hegemonic assumptions that perpetuate underdevelopment and inequality. Thank you.
Two questions. We have Professor Ronaldo and James and Niels Peterson. So, please.
Can I answer in Portuguese, and could you help me with translation, please? So I prefer. First, thanks for the questions. I signalized in the beginning, it's a first draft. No, it's not a complete thought. It's something in developing, but I think we have important questions here. First, the purification and provocation by Ronaldo. Eu reconheço a existência de vários movimentos dentro do Law and Economics. Eu não estou tratando isso como um bloco único, mas mesmo as ondas mais recentes, que mudam a perspectiva inicial do Posner, elas mantêm alguns pressupostos do individualismo metodológico que são insuficientes para uma abordagem mais completa de questões relativas ao desenvolvimento.
Well, you said it, you acknowledge the new pluralism in sideline economics. However, there seems, according to your view, some strong commitment to the methodological individualism that is shared by even the most current contemporary perspectives on law and economics. Yeah.
Então, uma perspectiva que ela é útil para alguns hard cases, mas não para todos os casos, né? Então, reconheço o pluralismo. O que a minha crítica é quando o Law and Economics ele aparece como a única racionalidade ou a melhor racionalidade possível para a decisão.
Okay, so the problem would be that the idea to limit law and economics as the only rationality that is applicable to solve different situations, in the sense that you mean that there's still some claim towards law and economics as being the only rationality applicable.
Exato. Reconheço outros autores, o Trubeck, Unger, professores mencionados pelo James. De fato, eles permitem uma abertura crítica, inclusive uma crítica epistemológica ao Law and Economics. Mas o que eu trago no diálogo é uma perspectiva específica da economia política latino-americana, do método histórico estrutural.
Okay, even accepting the contribution of people like Trubeck or Tamanaha, you think that there's a specific contribution of Latin American literature on the structural analysis that is important to put into place in this debate, yeah?
Exato. Que foca mais a estrutura e sua história, a sua genealogia, do que propriamente a racionalidade a partir do indivíduo.
Okay, that is more structural, it's more historical than focused on individual rationality compared to this other literature. Yeah?
De fato, como o professor James notou bem, o alvo é um processo de modernização conservadora, né? E o resgate de teorias do desenvolvimento mais plurais, né? E o que não significa que seja um não pluralismo, não é uma absolutização de uma alternativa contra a outra, né? Mas pensar estratégias que tomem em conta as possibilidades reais de transformação das estruturas, né? E a limitação da racionalidade econômica neoclássica como melhor interpretação do direito, ela é muito limitante no processo de desenvolvimento, né? Talvez o que marca a diferença entre o processo de modernização e o processo de desenvolvimento seja a simplificação da racionalidade da modernização dentro da perspectiva individualista, da perspectiva da microeconomia.
Okay, so the major intellectual enemy is of course the conservative modernization, and in this sense you are basically criticizing this attachment of these perspectives on neoclassical models rooted in the, individual methodological individualism instead of more structural analysis.
Em relação à questão da delegação aos experts, esse é um diálogo mais estreito com o texto do professor Peterson, que aponta três formas como as cortes vêm lidando com a questão da necessidade de um diálogo mais aprofundado, e uma das possibilidades é o diálogo com os experts, ainda que haja limitação, e o próprio professor Peterson reconhece isso no seu texto.
Okay, the dialogue with experts is just one alternative among others. That's basically the idea.
E que demanda, de qualquer forma, para o juiz um conhecimento prévio até para fazer uma avaliação do pluralismo que vem do painel dos experts.
And even this alternative requires from the judges some knowledge of what these experts are saying, in the sense they have to interact with them.
E talvez, por fim, não sei se eu passei por todas as questões, uma ilustração, um caso empírico, né? O professor Peterson questiona. Talvez um bom exemplo seja a definição do marco temporal por reconhecimento das terras indígenas no Brasil, né? E o uso da antropologia, dos estudos antropológicos para definição, para atribuição desse direito originário, né? Então não se trata aqui da aplicação de teorias da propriedade, e sim de uma leitura antropológica sobre o uso da terra, a apropriação da terra por esses povos originários para se delimitar um marco temporal. Então, dentro de um social science approach, a gente percebe para a questão indígena a necessidade de um more anthropological approach.
So a good example of this perspective is related to a current discussion at the Supreme Court level about the timeline for assigning to the indigenous peoples the right to property, if they were there, when they were there. So the whole debate about when the property right starts is connected to a lot of anthropological debate, and there has been a huge anthropological debate and discussions and reports explaining this. What is their connection with the land? What is their perspective about property? What is property for them? So this is a kind of anthropological approach, which is very useful and very, I think, very clearly applicable to the case.
Any other questions? Okay. Marcus? I would like to add, because I would make a question very similar. And it seems to me that when we discuss interdisciplinarity in legal education, we think about including course disciplines such as economy, anthropology, and then we keep the field of law kind of traditionally teached, and so you have this divide between the interdisciplinary studies and the law study, and then you don't actually break this frontier. And what we are proposing is, it seems to me, it's a different legal doctrine. So that's I think would be a challenge. That's my comment to your question.
Eu não tenho dúvida que passa. Of course. Eu não vejo uma limitação, e até por isso na crítica eu faço uma crítica a uma leitura hegemônica. Então, o que está se propondo é uma leitura talvez contra-hegemônica ou uma disputa por essa leitura que se tornou única a partir dessa posição de hegemonia, né? Isso, sem dúvida alguma, passa pela formação jurídica, né? E pelo próprio modo como o direito lida com outras ciências, né? No diálogo interdisciplinar. Isso eu falo mais pelo Brasil, eu não posso falar pela educação jurídica de outros lugares, mas há uma tendência no diálogo interdisciplinar do direito colonizar outras disciplinas, né? Existe muita dificuldade de um diálogo interdisciplinar franco, em que de fato você apreende uma linguagem científica que possa ser traduzida normativamente e não o contrário. Eu vejo isso acontecer claramente na área do planejamento urbano, que é uma área que eu atuo mais de perto, de como o direito urbanístico, de alguma forma, mata o urbanismo como técnica, transformando a ciência do urbanismo numa coisa completamente diferente, né? Então, sem dúvida alguma, passa por por estabelecimento de um outro tipo de diálogo entre as disciplinas das ciências sociais aplicadas, nas quais o direito está incluído, né? E pensando, inclusive, se em alguns casos mais paradigmáticos, se a gente não poderia avançar para um tipo de arbitragem, ou mesmo de uma magistratura uma magistratura especializada, ou não profissional. A gente já teve experiência no Brasil de magistratura eleita e não profissional, né? Então, a gente pode pensar em reformas institucionais que possa tornar o próprio ambiente jurídico mais plural e mais permeável a outras formas de pensar a sociedade.
All right, everybody, let's get started on the next session, which I discover I am in charge of. Some people are born chairpersons, some people become chairpersons, and some people have chairing thrust upon them. I'm in the third category this afternoon. We will start with ProfessorAna Nusdeo, who is talking, as you will see, about climate change in Brazil. I'll let you know when you get 25 minutes.
Thank you, James. And I hope you are listening well. Maybe I can do that. And I first would like to, now as a lecturer, to welcome everyone, and especially the colleagues from Münster, and to thank and congratulate my colleague, Ronaldo Macedo, for the efforts to organize this seminar. And so I have been working with climate change for a while, and then I will discuss the issue of the duty of states to implement climate policy and some implications of those duties in Brazilian law. So I will address basically three issues. First, the state obligations in international law. And the second issue is the constitutional obligations of climate protection in Brazil. And finally, I will address some cases of climate litigation in Brazil that arises from the state failure to comply with those obligations. So, starting with the first part, the state obligations in international law, they are basically defined in the Paris Agreement that was adopted in 2015. That's within the frame of the United Nations Framework Convention on Climate Change. And the Paris Agreement has some elements. The first important element is that it defines a temperature increase limit that should be well below 2 Celsius and preferably of 1.5 Celsius. And the agreement doesn't establish a specific target for countries. That's why it's said to have a bottom-up structure. So countries themselves establish their mitigation and adaptation targets and goals through their nationally determined contributions. So countries have procedural obligations of preparation, communication, maintenance, and updating successive nationally determined contributions. And there's some discussions about whether the fulfillment of the nationally determined contributions would be binding. But the language of the Paris Agreement does not suggest this bindingness, as it determines that parties shall pursue domestic mitigation measures with the aim of achieving objectives of such contributions, which means parties shall endeavor and make efforts to fulfill their obligations, but they are not bound, they are not they are not required to really fulfill those the objectives of their contributions. So the obligations in connection to the nationally determined contribution are considered as obligation of conduct instead of obligations of results. Very recently, the International Court of Justice issued an advisory opinion that was in 23rd July of this year. And this advisory opinion referred to state obligations in connection to climate change. And the court delved into the issue of the content of the nationally determined contribution and considered that there isn't a discretion on the definition of the content of the NDC, the nationally determined contribution, because Article 4.3 and determines another standards of due diligence that are present in international law, limits this discretion in the definition of the content of the contribution, which means that it's not only a formal obligation to present a contribution, but this contribution needs to show some ambition. especially because the Paris Agreement requires them to be more demanding over time, which means successive contributions need to show more ambition. And that ambition should be kind of proportional to the general goal to limit the increase of temperature, of the Earth temperature in 1.5 Celsius. And of course, this obligation is moderated by the principle of common but the shared but differentiated responsibilities, which attributes more responsibility to developed countries in comparison to developing countries. And with regards to the implementation of nationally determined contributions, the court confirmed the legal nature of obligation of conduct and not of results of the implementation, but consider that they should be assessed on the basis of whether the part also exercised a due diligence in its efforts and in the deploying appropriate means to take domestic mitigation measures. That includes the regulation of activities carried out by private actors. And the court also examined the relationship between human rights protection and climate change, and considered a strong relationship, as human rights cannot be fulfilled in a context of severe climate change, and required that measures that human right protection obligations requires countries to establish measures of mitigation and adaptation, which also includes the definition of standards of legislation and the regulation of the activities of the private sector. I turn now to the second part of this presentation, which addresses the constitutional obligation of climate protection in Brazil. And so Brazil doesn't refer to climate in the constitution, but it does establish a right to a balanced environment as a fundamental right. So we have this specific provision in our constitution. And another important article is Article 2nd, paragraph, Article 5, paragraph 2nd, which considers the protection of human rights established in international treaties as rights protected according to Brazilian constitution. But the legal status of these treaties and rights depends on a procedure of approval of this international treaty in the Brazilian legislative branch. So depending on this procedure, the treaty and the right can be considered as a norm of a constitutional level, or they can be considered as a norm of supra-legal level, which means a norm that's under the constitution but above the ordinary legislation. And that would be interesting in some cases that has been decided by the Brazilian Supreme Court. And the constitution established protection of some national biomes, such as the Amazon forest and the Atlantic forests, for instance. And also, there is a provision that creates a kind of action, the request for a declaration of non-compliance with fundamental principles, by which some legitimized parts can file a claim directly in the Supreme Court when a fundamental principle, often a right, is threatened by the state, the public powers. Something got wrong here, I'm afraid. Well, I think it's better to go on than try to solve this problem. But here I go to the third part of the presentation, which addresses climate litigation in Brazil, climate litigation that arises from the failure of the state to comply with its environmental and climate protection obligations. So the situation in the previous government, as you probably know, is that it weakened climate policies, and the present government resumed those climate policies and environmental policies, but faces the challenge of combating the environmental crime, and also suffers the pressure of the economic sectors against a strong environmental legislation. And so that context, especially the weakening of climate policies of former government, triggered climate litigation in Brazil. Of course, nowadays we have other kinds of climate litigation against private parties, especially big deforestation actors. But what I will consider here are litigation against government. And we have, and thanks to this, the existence of this action, the AGPF, this Declaration of Fundamental Rights, and we have a climate litigation that went directly to the Supreme Court. And this litigation in Brazil, it confirms somehow a classification, a distinction brought by Jacqueline Pugh and Jolene Lin that points out that in Global North, climate litigation claims for an increase of ambition of climate policy. And I remember your reference to Neubauer case that required, where the Supreme Court required more a more ambition legislation to be issued. And the same happened in Urgenda case in Holland, but when the court required the executive branch to be more ambitious. In Global South, we tend to have good legislation that are not really effective. So climate litigation try to push the implementation of the existing rules and policies. And that's what happened in Brazil in those cases I'm presenting. And so the first case I'd like to comment is the AGPF 708 that was filed in 2020, where trying to where the Supreme Court recognized that the federal government's omission to allocate resources from the climate fund was unconstitutional, was an unconstitutional omission of its obligations. So the decision was delivered in 2022. And the important aspect of this decision is that the Paris Agreement was considered as a human rights treaty. So it benefited from this provision of Article 5, paragraph 2, that consider this the rights protected in the treaty as a supralegal, as having a supralegal norm status. So the Supreme Court exercised here also a conventionality control, which regards and refers to the adequation of the legislation, the Brazilian legislation, to those international obligations. I consider that according to the obligations in the Paris Agreement, in addition to the constitutional obligations, this fund needed, the climate fund needed to be put at work again, because here, to refer, the former government paralyzed these funds. That is an instrument of the climate policy. Well, the second action that I want to refer is the AGPF 743 that was filed also in 2020, and the claim referred to the establishment of measures to prevent the reemergence of fires in the biomes of the Pantanal and the Amazon. This map shows the Brazilian biomes, and the Amazon forest is represented in green, in dark green, and the Pantanal is represented in blue. And in 2020, there was big fires and intense fires in those biomes, and so the plant chiefs, which were political parties, required these measures to prevent the situation and to avoid more damages in the following years. And the decision of the Supreme Court determined required the government to present a plan to prevent and combat fires in Pantanal and Amazon region in a deadline of 90 days. And also a presentation of a complement to the action plan for the prevention and control of deforestation in the legal Amazon, the PPC-DEN. Just to refer, this PPC-DEN is a very important plan that was created in 2003, and which allowed very good results in the combat of deforestation in the Amazon forest. And the plan also was paralyzed during the former government, so the Supreme Court determined the reassumption of the federal government to resume this plan, and that was also a deadline for that measure to be made. And so this second case brought also some substantial innovations in the legal doctrine, because after the decision, and that's an issue of these structural actions that requires a relationship between the courts and the executive branch after the decision, and during this monitoring hearings that followed the decision, the reporting judge issued an enforcement decision in 2025, earlier this year. So this interpretative decision basically referred to possible measures to combat illegal deforestation, especially a criminal deforestation. So there was this monitoring decisions came to the idea that more strong answers were necessary to combat this deforestation process in those biomes. And so the discussion was the possibility of application of this of some constitutional and legal rules that would provide these stronger answers. The first one is Article 243 of the Constitution that establishes the possibility of expropriation without compensation of rural and urban properties used for illegal cultivation of psychotropic plants or the exploitation of slave labor. And that the possibility of this application was rejected because of the the rule was considered as numerous clauses, which means legality principle wouldn't allow the expansion of the possibilities of application of such a rule. But Article 186(2) of the Constitution establishes that the social function of the rural property have also an environmental dimension. So according to Article 186, the rural property performs its social function when it's productive, but also when it provides for an environmental protection. When the property and the property owner obeys the environmental legislation. And so the possibility of expropriation with a compensation paid with titles of agricultural debt that's provided for in case when the rural property does not fulfill the social function was accepted. And that was a kind of an innovation because although we have this provision, the expropriation with this kind of expropriation for the is for related to the failure to comply with the social function was limited to unproductive properties. And of course, the application of this new interpretation will depend on a case-by-case expropriation process that will be submitted to the judiciary. And so I can say it's going to be effective, but it's an important signalization in the sense of the importance of this environmental dimension. And finally, there's a federal decree of year 2010 that regulates land regularization of properties in the Amazon. Because here, I think it's necessary to make a note that especially in the Amazon region, not every landowner has the due title of the property. We have this fungiary problems, and so we have rules for the regularization, and this federal decree requires include a condition precedent related to compliance with environmental legislation for 10 years. So here, the reporting judge considered this rule as an important provision to strengthen the combat to deforestation as well. And those cases show some procedural innovations, especially the what we can call structural actions. And I heard Professor Michaela Hellbrunner address this issue yesterday. I'm sorry, I couldn't be here, and today, unfortunately, she's not here. But and that issue is being discussed here in Brazil in different areas, and in the environmental area is one of them. Some those environmental cases, some environmental cases really addresses the creation and improvement of public programs. And of course, that requires not only a legal decision, but an enforcement process that tends to be very complex. And when we talk about structural actions, I think we go back to a tradition, and I think we can go back to some important authors such as Owen Fies, a professor of Yale, Owen Fies, that worked on the subject of state reforms and social institutional reforms, especially related to the problem of the segregation, an issue that the professor also referred as the Brown case. And so I don't think those environmental cases really require the reforming of social institutions, maybe to be really solved. But we are basically talking about a complex public program programs. And so, and we have just kind of cases both at the Supreme Court, such as the AGPFs, but also in civil public actions that are filed in the judiciary in general. And the second case I referred, the AGPF 743, it required many supervisory hearings, diligence, and also the interpretative decisions, such as the one I referred. I go now to the conclusion. So there is we can identify this right turn as it's referred in the literature. The right turn in climate litigation allowed a direction of litigation, challenged the inaction of the state in constitutional courts and even in international human rights courts, which provided for, I'm sorry for the, there's a small graphic mistakes, innovations in constitutional norms, interpretation, as the case of the social function, the environmental dimension, social function of the property shows. We have also this aspect of monitoring decision and structural actions that establish a relationship between the judiciary decision, the judiciary branch and the other branch. That's also an issue subject of debate. And here in Brazil, what we can see in environmental cases is that environmental problems are very complex because they are rooted in some economic relations and economic pressures and political interests. And so these judicial decisions and supervision, especially of the Supreme Court, perhaps show some potential to improve a problem, to solve somehow a problem of lack of coordination among governmental bodies, especially considering the size of the countries and the different levels of administration. But we always have this debatable relationship between powers and the limits of state power limitation doctrine. So I thank you for your attention. Thank you so much for the questions, and thank you so much for this history and this tale about the what happened in the approval of the bill, because that set so much light on the case, on the Neubauer case. And so I reply to Ronaldo. And yes, I understand your point. So the actions are filed against those who apply the laws, because it's difficult to feel a claim against those who cause the climate change. Some remarks that actually this the situation is changing, and it's getting easier to suit those who cause climate change, because there is a process of scientific progress that can point the main responsible for the large amount of emissions. And we have the measure, the carbon measure, for example. They are responsible for a significant percentage of the emissions. And so some litigation against them are arising now, and with results that are not really defined yet. But you know that this process of suing the carbon measures are happening. And in Brazil, we have this process. What happens in Brazil is that the main most part of the emissions come from deforestation. that's why we need to go to these old strategies of fiscalization and enforcement of legislation, because we have, let's say, you mentioned old approaches. We have like old conducts as well of emissions. Maybe if we had developed more, we would have more emissions from the energy sector. And of course, this is growing as well, but we still are dominated by those emissions from the agriculture and illegal deforestation. That's why old approaches are still necessary. But on the other hand, when we consider those those groups of claims that, as Professor Lepsius mentioned, we can find all over the world, and we have this group of actions of claims that requires more ambition of legislation. And then we go to this discussion that was present in the debates after your presentation of goals and means. And so basically we have some claims that define the need for more ambitions on policies, but left the means of for the achievement of this goal for legislators or for the administrative branch. So the judiciary wouldn't define, well, we need to create incentives and we need to create markets, because that's it's up to the other branches. And then we would have this model of determining ambition and let the other branches do their work. And I think I answered your question, I hope, I'm not sure. And Professor Lepsius, thank you again for these comments. I think that's very interesting, and I will add your conclusion. I accept the suggestion. And your comment reminds me of an author that I think that is very interesting. Is Professor Neil Comazar from the University of Wisconsin. I don't know whether you know his work, and his work with comparative institutional analysis. And your comment goes very much in this direction. He compares market, political process, and the judiciary, the courts. And so here we have a comparative analysis of whether courts or political process works better. And of course, he works on the based on other concepts of such as the concentration of the interests, and he doesn't address lobby so directly. But I think that we have in this contest, we have a superior, the Kurds are better equipped to curb the action of lobbies, because they do not have, exactly because they are politically insulated. And I think that would make Kurds more suited for this job. But of course, it pays its price, and because Kurds became, it seems that they are trying to grab more and more power, and that in the long run, I'm afraid that erodes its legitimacy somehow. And so, Niels Jensen question. Yeah, interesting. And then you mentioned Kurds acts against democratic majorities, and in the sense that it's interesting because environmental interest tends to be a general interest, so that would be an interest of the majority, but the perception and the opinion of the majority is against environmental protection, and that makes the situation a little messy and difficult to classify. I wouldn't say it's a minority interest, but somehow your points. Last week I was in a seminar and there was yes, please. The will of majority. Okay. Yeah. Yes, but last week I was in a seminar and there was at the opening, they invited the president of the Supreme Court, that's Minister Luis Barroso, that's constitutional law professor, and he has this idea that maybe, you know, he's very attached to this idea that the Supreme Court needs to perform a contra-majoritarian role. And he said that environmental law can be contra-majoritarian in a sense because the most affected are poor people and, you know, and with a racial aspect and so on. And so I'm just commenting because I'm not really sure of a direct answer to your comments, but I think we have just perhaps just unclear situation of how to classify this the interest and the role of courts. So thank you for the comment. Yeah, I think that's a very interesting issue, and I think that maybe is okay. Are you incentivated by the president of the table? I can think about the Brazilian case and these structural actions that allows some negotiation. Even the AGPF 745 43 I mentioned is being held. The execution of the decision is being including many very frequent audiences, hearings with public administrators of the states of the Amazon states, and they are really thinking in the capillarity of in the effectiveness of some programs like the implementation of the agrarian registry and the program to prevent fire. So maybe it's another role the courts fulfilling that I'm not. It's not exactly their original role, but of trying to get this capillarity.
Use the 45 seconds. Thank you. Yes. Thank you. All right. We will then move straight along to Professor AlbertoAmaral, who is talking on competition law and environmental protection. I will microphone.
Thank you, James. First of all, I praise so much the organization of this seminar, the Ronaldo and Peterson's initiative in promoting of this seminar with a view to identify possibilities of researches between our two universities. I will divide my presentation in three parts. First part dedicated to investigate differences between regulation and antitrust law. The second part driven to a short analysis of new markets, the necessity for new markets and new indexes. And the third part, some recommendations which don't have a nature of panacea that can improve the situation of the planet. The activity of monopolies and oligopolies is at the root of both degradation of the nature and climate change. Here, it is urgent to dilute power structures, disseminate economic knowledge, and value cooperation. Knowledge and value cooperation objectives of this nature require the regulation of the economy with the aim of establishing real equality of opportunities for those who participate in the market. Unlike antitrust law, which is limited to sanction illicit behavior, it seeks to impose competition in sectors where the structural conditions of the market prevent it from being established only through an active application of antitrust law. The latter attempts to correct market imperfections that prevent efficient results. It is, however, essentially passive, controlling the formation of structures and sanctioning behaviors. This is what administrative doctrine usually calls acts of control and supervision, through which the state does not create public good, but limits itself to supervising or controlling it. Regulation, on the other hand, cannot be limited to this function. Active intervention is needed, which is not limited to control, but to true creation of public utility through competition. Competition provides, as a minimum value to agents operating in the market, the knowledge and critical evaluation of options offered. Information and freedom of choice enable good decisions in the economic sphere. Now, fundamental to the existence of a process of free choice and discovery of the best options on the market is not only the existence of a price that is not altered by artificial conditions of supply and demand, which therefore represents the marginal utility of the product, as new classicals would have it, but also that there is an effective real or potential plurality of choice between products based, among other factors, on price, quality, and regional preferences. The possibility of choice is, in fact, the core of competition itself. In the absence of opportunity to choose, it would not be feasible to determine the utility of the consumer of the alternative that was not the object of preference. If the alternative really exists, its utility will be known when the consumer actually has access to it. Monopolies are harmful to the environment and, as could be expected, disastrous for a stable climate. Causes concept of transaction costs should be supplemented by the inclusion gains, since covering the interests of stakeholders makes the individual company and the economy as a whole more efficient. While changes in the corporate structure have reduced costs, companies have evolved largely through the inclusion of the new participants in the management of companies, taking into account the interests of other stakeholders, has decisively driven the growth of large modern companies. As a result, there have been fewer conflicts and more legitimate and sustainable goals in the long term. The inclusion of environmental interests is much more complex because it encompasses everything from the community dependent on a river to meet its water needs to the effects of global warming on the scarcity of agricultural land, water, food, and clean energy. In this context, the issue at stake is to outline improved forms of representation compared to those currently in place in the public and private spheres. As an illustration, such mechanisms could include representatives of NGOs, environmental experts, and the participation of members of directly affected communities in the corporate decision-making process. These comments do not tend, as is easy to see, to suggest the abolition of the market, but rather seek an institutional reorganization that is not guided by managed costs and transaction costs. It is urgent to create new markets and new indexes, expanding the level of information held by consumers. It is possible to distinguish, initially, situations that allow the coexistence of different indexes to mediate economic relations from those in which this task becomes impossible. The consumer is often given the opportunity to choose the index that will define decisions in the market. This is not, however, an alternative that exists on all occasions. In the case of educational or health institutions, the essentiality of the good offered ensures that quality criteria, rather than those related to price, constitute the best option. The difficulty is aggravated when several indexes coexist due to the attraction of the price criterion because it serves as residual economic availability for the consumer. The choice of the price criterion is natural, not because it represents a real index of utility for the consumer, but because choosing the product with the lowest price favors the greatest amount of resources. In other words, economic well-being. In order to deal with shortages, it is necessary to establish new comparative product indexes. This type of index should focus on two problems. Firstly, it must be able to transmit data on the consumer's residual well-being, which is one of the main factors that leads to the predominance of the current price criterion for the choice in the market. That is, the consumer must understand that well-being results from the consumption of this product. Secondly, the index must be able to convey clear and simplified information to the consumer about the scarcity of the product and the resources needed for its production. Only in this way it can be a useful element for stimulating economic flows in the medium and long term, since the consumer will have a true and fair notion of the scarcity, both real and residual, involved in the consumption of the product. The consumer will benefit from some measures, including the social efficiency of the product, the purpose of which is to assess compliance with labor and environmental rules. Qualified institutions take on the task of developing one or more indexes that would be undeniably useful to the consumer. At the same time, respect for social and environmental values would be encouraged, replacing the price standard with other criteria. Is time-consuming, but experience is unequivocal in substantially expanding information. Transparency and access to information would rely on institutional creativity to create or modify markets that value the quality of the goods rather than the price. There is no small probability of limited use of social impact indexes when considering the reality already studied that market interactions increase the propensity for profit and attenuate the appeal to moral standards among economic agents. The risk exposed above declines. If the indexes and fluctuations are widely publicized, and if there is broad knowledge of the result of the economic flows after the indexes are introduced. The fact that alternative products with better environmental and real standards exist, and that these products are not consumed can be, if well publicized, an effective instrument of awareness and moral pressure on consumers to use such indexes as a tool for choice. In the medium term, it is possible to generalize the choice of a social or environmental index due to institutional incentives. The criterion of low price as the main decision-making element for consumers would be restricted to the type of consumer or user who is simply not in a financial situation to trade price for social or environmental improvement, assuming, of course, that such indexes always point in the opposite direction to prices, which is not necessarily true. The problem may also have repercussions on supply. If it is observed that a given company or product line presents a consistently inverse relationship between prices and social or environmental indicators, it is possible to imagine compensatory measures such as a tax or surcharge, with the amount of the tax being used to create a fund allocated to specifically for the improvement of the social environmental elements that were contemplated by these indexes. In the absence of certainty about the economic equilibrium, it is suggested the introduction of institutional elements to include new interests in the market operations through changes in the demand and supply of the product. Over the last 5 decades, monopolies have created the differentiation between consumers, including in the environment. The same people who environmentally make environmentally friendly products, at least in appearance, sell them at higher prices for those who can afford them or not, who obtain cost reduction in cheaper versions of the same goods or similar ones precisely from the destruction of the environment. The more power they have, the more they can exaggerate the differences between products, precisely so that discrimination is more effective. That is, consumers of one do not migrate to the other. Some suggestions could help improve the situation of the planet. The first would be to apply and better develop the discipline of the common goods to environmentally sensitive resources and assets dominated by large economic structures. This would involve the participation of the affected communities who have an interest in conserving them, in the management of these assets, and in the enjoyment of the natural resources they produce. Elinor Ostrom, winner of the Nobel Prize in Economics, has demonstrated the positive effects of this practice. Another suggestion, which is not a panacea, are markets that induce positive screening of companies and products, creating special segments on stock exchanges that list only companies that truly protect the environment with zero or positive environmental impact, has the capacity to generate a race to the positive in relation to investment funds and investors in general, who increasingly start to invest resources only in those companies. Ultimately, if well regulated and self-regulated, it could lead to the disappearance of environmental free riders who would be exposed in new markets with positive impact. The same can be said about creating new prices for products in environmental and social terms, alongside the economic value or utility value of products displayed in the traditional prices. It is possible to create an environmental price and a social price, that is, a measure or the environmental destruction and hardship caused by the product, those originating from the slave labor, for example. Thus, consumers would also be exposed to the choice of paying an attractive economic price, knowing that this would generate a high environmental price and or a high social price. In addition to influencing consumer choice, this alternative would be capable of justifying regulatory or tax interventions, generating penalties or retributions for the marketing of products that recurrently mean prices in different sense. Low economic price, but high environmental price. A fact already duly highlighted. Obviously, such a solution is only feasible in the presence of reliable state or global certification capable of attesting fully and without marketing the true environmental and social effects of the product. Thank you.
Questions?
Thank you for your question.
Someone sent a student needed to go, but sent a question here.
You just read it?
Yeah, please. The student's name is Eduardo Petella, and he said he was delighted with all the presentations. And just yesterday in Brazil, a remarkable decision highlighted the tensions between environmental governance and competition law. For almost 20 years, Brazil had a voluntary pact known as the Soy Moratorium, signed in 2006 by major traders, NGOs, and government agencies. It prohibited the purchase of soybeans grown on land deforested in the Amazon after 2008, and it became internationally recognized as a successful case of private environmental governance. Many studies credit it with helping to decouple soy expansion from deforestation. Yet yesterday, Brazil's antitrust authority, CADE, suspended the moratorium. It argued that, although environmentally effective, the pact might constitute a form of market collusion, since traders were collectively setting purchasing criteria and potentially excluding lawful producers. Companies are now under orders to remove reference to the moratorium and stop sharing related data under the threat of very large fines. This also raises uncertainty about how foreign markets will react. The European Union, for instance, is about to enforce its new deforestation regulation, which may demand stricter due diligence from Brazilian exporters. So the suspension not only unsettles domestic governance, but also creates doubts about Brazil's positioning in international commodity markets. Against this background, my question is broader and more theoretical. What should we make of situations where private sustainability agreements, designed to achieve environmental goals, come into conflict with principles of competition law? And more generally, how should we understand the legitimacy and limits of such private governance mechanisms when they increasingly intersect with state regulation and international legal frameworks? That's the question.
Thank you so much. There are more questions?
Why don't you answer those two?
Okay.
See where we go.
Thank you so much for interesting, intriguing questions. As regards Marina's question, I would say that I defend the simultaneous application of mandatory and voluntary rules and indexes created to protect the environment and to avoid climate changes. And some criteria that I mentioned are voluntary. For example, the Brazilian Stock Exchange, the São Paulo Stock Exchange, created the new market. The new market is a form of disclosing information, companies presenting a great level of environmental protection. For example, it's not enough, certainly, but it's a way of disclosing information to consumer, for example. But in other cases, we need to adopt some mandatory measures. For example, if you adopted social prices, identifying the origin of product, the product is or not environmentally friendly to the environment, or if it provoked the destruction of the environment, you can accumulate the application of a tax or surcharge and to allocate resources coming from a fund created with this and to promote environmental goals. okay, and advocate, therefore, the combination of voluntary and mandatory measures. As regards the second question, private agreements are valid only in accordance with the Brazilian law, for example, if they are in accordance with public rules. And this exposes the tension between a contractarian law that many times can arise from private agreements and the nature of public rules, the aim of which is to impose mandatory rules on all private actors or all people in a society. And the case focus on the question is very interesting and very important because it has repercussions internationally and can bring consequences for the Brazilian exports, given the fact that soybeans in Brazil is cultivated in areas, in vast areas where deforestation is a current reality.
Yes. Yes.
Yes.
That's the question from Gerald Mäsch, then there's one from Niels Janssen.
Okay. Thank you for questions. I agree with the questions related to the economic considerations in the consumer's decision or decisions, and the Brazilian law presents the same perspective that the German law has, unfortunately. But a way of overcoming the situation is the adoption of certification, global certification, a reliable state, multiple criteria that can deal with different data, the data about the scarcity of the product, how much the product affects the environment, and how much the product is environmentally friendly. And why is this? Perhaps this is the root of our society, you know. It is the great appeal of some criteria that the consideration that emphasizing the price criterion leaves the consumer the greatest amount of economic resources, the economic well-being. This is the root of these, no? The emphasis should be displaced to another way of viewing this reality. And this is the question to offer the consumer a broader possibility to decide within the market sphere, in which it can appreciate the social environmental consequences, the possible violation of certain rules. For example, if a product is made with the use of slave labor, for example, or if the product implies the environmental degradation. The indexes have the virtue to disclose those ideas to consumer. And this can work with a view to changing this picture.
Yes, there's one last question. We've got 3 minutes, so again, you're on the clock.
It's a very, very interesting question. I don't have a right answer about this at this moment. But I would say that the enhancement of certification is absolutely fundamental on this topic, and the certification needs to present all consequences generated by a product in terms of environmental protection or in social costs. The great challenge to be faced is that certification can be really a form of depicting a reality of the production, which conditions are employed in the production of a good, and how impact this production had in reality. Thank you.
And that brings us to time, so let's thank Professor Amaral.